Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida. I offer content and commentary on current events in the law as well as some general legal topics, but I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. Well, remember yesterday when we talked about the problem with this smoking gun document that the defense in this case had found, and that it had just fallen into their lap, and they wanted to impeach him with it, and the plaintiff said, hey, there's nothing to impeach him, he testified about this. Well, the judge kind of figured things out a little bit late, but he figured things out yesterday, and holy cow, this was bad. Before I go too far here, I want to say one thing, and that is I really like this judge. He would be a good judge to try a case in front of because he doesn't get rattled. He doesn't make decisions on the fly. He doesn't just, snap out there and lash out at people willy-nilly. He takes some time to think about things. So the plaintiffs have a request to make of the court. Let's get to that.
Yes, Your Honor. To the extent the court's inclined to grant the relief, we would need to try to make travel plans very, very quickly. The prospective witness is located in Arizona, and there aren't many flights from there to here.
And have you had communications with Mr. Conway?
After receipt of his letter yesterday, I called Mr. Connolly up, and he told me that he was extremely busy, but that when I explained the importance of his testimony to correct the record, said he would do his absolute best to clear the decks and be here for Thursday. But I told him not to make any travel plans yet because the court had not granted our relief, and if the relief was denied, there was no point in him flying all the way out here. So that's the most I know about his availability to attend.
All right. And in the third paragraph of request, you got any other relief? Did you have anything specifically in mind?
Your Honor, the only other thing if Mr. Conway is able to make it here, then I think that will suffice. If he's not able to make it here, we've been highly prejudiced. We also have now found out, which we did not know until we received a copy of the production, that Mr. Young's security clearance has been dropped as of 2022. We have no ability to get that in beyond calling Mr. Young in a rebuttal case, which we will try to do. But so we would ask permission to submit the documents received from Mr. Conway into evidence, the ones where he says that the security relationship was dissolved as of 2022, if he cannot make it here.
And here is the rationale for that request. CNN knew, based on the information they got from Helios Global, that Mr. Young no longer had a security clearance, and so much of what they claimed was simply false, and they knew it to be false.
This was an email from Mr. Conway to Mr. Bailey, counsel to CNN, Mr. McManus to Mr. Bailey for CNN from his Helios Global account. This correspondence was not submitted with the surprise contract, so to speak, and they state clearly in them that as of 2022, here it says, we retained Mr. Young's clearance through approximately November 2022. In the event these requirements reemerged, but they did not. Ultimately, we administratively dropped Mr. Young from our security clearance roles, thus ending any relationship / affiliation. And so we'd ask to be able to obtain a declaration of some kind or a business record of some kind. I don't know, Your Honor. I mean, we've been put in a very, very untenable situation given the late disclosure and the partial disclosures.
So as you might imagine, the judge was a little irked about this and had some questions for CNN's defense counsel.
Yes, Ron.
Your Honor, I got to say I'm at a loss. We didn't have this document from Helios because plaintiff never produced it in discovery. And we know he had it because I asked him on the stand, this was a DocuSign, and he said, no, it was a wet signature. which means he had it in December of 2021.
Remember this argument because it's going to come back and haunt Mr. Axelrod later on.
Now, the idea that they've been prejudiced because we went out and got the document, it is kind of far-fetched.
I'm going to save us all a little time here. Basically, the argument that he makes is that because the redirect cleaned up this argument, well, there's no problem. But that's not the issue, as we'll soon see.
There's no clarification needed. If Mr. Young wanted to call Ian Conway, 2 years ago, he should have noticed him as a witness, and he could have called him as a witness in this case.
All right, and if you wanted to get the records from Helios Global, you should have sent a subpoena with a notice of production sent 10 days before you served a subpoena during the discovery phase of this case. I mean, I remember we argued motions to quash yesterday. Well, you didn't really argue because I just granted them. My whole problem is they were doing discovery via use of a trial subpoena.
And we were not, Your Honor. We subpoenaed Mr. McManus, not Ian Conway, because we had found out in preparation for trial that to have a company hold your security clearance, you have to have a commercial relationship with them. And we suspected that Mr. Young would deny that on the stand. So we subpoenaed Mr. McManus as an impeachment witness as necessary. We did not.
Never listed anybody on a witness list from Helios, affiliated with Helios, right?
We did not.
And therein, at least partially, lies their problem. They're trying to do discovery during the course of a trial, or at least immediately before the course of a trial, after the discovery phase is closed. Now, you can do that, but you have to file a motion and you have to take the proper steps. You can't just wait to get to the courthouse steps and say, holy cow, we didn't put our case together right. But that is apparently exactly what happened here with CNN.
Your Honor, I'm not sitting here asking for sanctions. I'm just saying we have been massively prejudiced, and we should be able to clear the record. The jury should not be misled.
Your Honor, you can't be prejudiced by introduction of a document that you knew existed. And you already found in the spoliation order that as of December of 2021, Mr. Young knew he was going to be bringing this lawsuit or was contemplating it. You can't get around your discovery obligations by signing a document, then sending it off and saying, I no longer have it, can't produce it. That's what happened here. I mean, he got the contract.
I sign a document, send it off. It's within a company's possession, custody, or control. What is my discovery obligation to go to their records, dig through their files, and find a copy of a document I signed several years ago?
That's not what I was suggesting, Your Honor.
It was. It was. You said he can't shirk his discovery responsibilities by signing a document, sending it off, and then say, I don't have it.
He had it, is what I'm saying.
I get the court reporter to read back exactly what you said, but I think I verbatim said exactly what you said.
Your Honor, the point I'm trying
I'm
to
tired of these blatant misrepresentations that are being made, and they're being made by both of y'all. And maybe they're not 100% lies, maybe they're leaving out a little bit of the truth in making the representation so you can carefully say, well, I didn't exactly say that. But you said he's lied to it because he doesn't have any work, but you had no proof that he had work because you're arguing that he signed a security agreement so they could hold his security clearance. But I didn't lie and say he had work. We're taking a break. I'm going to go read this real quick. Let me ask you one last question, Mr. Axelrod. You said, we were going to call Helios Global or whoever it was from there as a potential rebuttal witness. And that's why we served a subpoena. We didn't need to list a rebuttal witness on our exhibit list. But you also had production of documents from non-parties. I remember reading 2 motions to quash that verbatim said Rule 1.351 expressly provides the rule that is the exclusive procedure, in quotes, the open quote, exclusive procedure, close quote, for obtaining documents from non-parties without a deposition. Your subpoena for trial to whomever at Helios had a production request. The motion also says that the motions that I remember reading said that 1.351 requires the notice to the other side. How were you not conducting discovery pursuant to 1.351 in sending a subpoena ducis tecum to Helios Global without giving notice to the other side?
Judge, I'm going to take ownership of that. When I called Mr. Friedman this morning after reading the motion. I was asked to prepare a trial subpoena, and the subpoena came across my desk. Paralegal asked me if we needed to send notice of this to the other side. I told her, no, it's a witness subpoena in 38 years. I've never served copies of witness subpoenas to the other side and don't recall getting copies of witness subpoenas. I was looking at it as a witness subpoena, not a document production request. There was a ducus tecum component to it. I don't recall seeing it, but it was there, and I'm responsible for that. So if the rule requires notice of a witness subpoena that has a document production request to it, that's on me, and I take responsibility for that. And I told Mr. Freeman that.
All right, well, and Mr. Axelrod made the representation that fortuitously we ended up just falling into our lap at the last minute. But it wasn't fortuitous because it was pursuant to that witness subpoena.
That is true.
So at this point, our judge decides, I really need to look at the transcript and think about this and maybe see what I need to do, because this is important and it's important to both sides. And, I want to make sure I get the right ruling here. And the jury isn't in here. The jury hasn't even been seated yet. This is first thing in the morning. The jury is probably sitting in the jury room going, what in the heck is taking them so long? But at any rate, the judge is thinking about this. I wish that every judge I had ever tried a case in front of would have thought about things the way this judge does, because he's not making snap decisions that are wind up being, overturned on appeal. It's clear that he is demonstrating the use of his discretion. And of course, all evidentiary questions are questions of discretion on the trial judge. And that's what he's demonstrating by his calm, contemplative manner of going about deciding these issues. Now, let's see what he decided.
All right, I went back through and I was reading the trial transcript that preceded the sidebar and then adjourning with the jury and the discussions that we had with the Helios document that was handed, 589? I think defense 589 was the document that was handed to Mr. Young during the cross-examination. I think I made comments throughout the course of this case about how counsel was conducting themselves, how everything was a surprise, a last-minute thing, how counsel was referring to each other in the course of their arguments, had to impose a $100 fine. I find it rich that we've got discovery being done at the same time a motion to quash is being filed, arguing that the plaintiffs are violating the rules by sending out trial subpoenas when the defense is doing the exact same thing. We have representations being made to the court that we were just fortuitous to get this. It wasn't fortuitous. It was you were doing the same thing that the plaintiffs were doing and sending a trial subpoena for documents without notice to the other side in violation of Rule 1.351 that y'all cited in a couple motions. And just saying that this showed up in our lap. You represented me this morning. We didn't accuse him of anything, of having anything beyond a security agreement. But that was clearly the implication that was being made when we were arguing about the document, because you wanted to impeach him with it, despite the fact he admitted to signing a security doc. Then you changed it. We want to use it substantively, and it got admitted into evidence. And it was admitted into evidence under my Binger analysis of something that, there's not prejudice to the other side, was primarily the reason. Had I known it been discovery being conducted after the deadline, there was no way in hell that the document would have been admitted into evidence. Mr. Axelrod, I don't know how many times in this transcript, I didn't bring a piece of paper back with me, how many times you called Mr. Young a liar.
Yes, Your Honor.
But yet in his deposition, he acknowledged having his security being held by Helios Global, which is exactly what that document is and which was exactly what he testified to. I think an apology from you was clearly in order to Mr. Young for the number of times in front of this court and streamed around the world that you called Mr. Young a liar for failing to disclose a document that wasn't that you have no proof was within his possession, custody, or control. You know, everybody here, I don't know how much money we're clicking off an hour in lawyer bills in this case, and how much credentials the lawyers have in this case. The case has been pending for 2.5 years in my court. And I made a joke, looking back through this transcript, I made a joke of you only have a week and a half to do more discovery in this case, that we finish up the trial, but it seems like everybody wanted to do everything at the last minute without telling the other side that we're going to do this discovery and then accuse the other person of being the bad person. And I said in this transcript, I'm not going to decide the case based on who can sling the most mud at each other and make each other look out to be the worst person. I think it came up in the course of things. This isn't kindergarten. Y'all matriculated from kindergarten a long, long, long time ago. Or at least that's what it says because y'all have bar licenses. I'm troubled by all of this that happened. The easiest thing and the clear thing I'm doing is I'm permitting you to call Mr. Conway and get him here to testify and rebuttal. But I'm overly concerned with the level of professionalism or lack thereof that's here. I'm overly concerned. I mean, the transcript of what I read, we said at sidebar when we were arguing after we excused the jury, conflicts Mr. Axelrod with the argument you made today to me. The argument you were making when we were arguing about the document last week, we're suggesting that, oh, we got the smoking gun. This is the crucial document in our case. I don't know how many times I've heard that from both sides in this case. Or the crucial witness. Like every document, the thousands of documents we have in evidence in this case are the crucial documents. But this was being represented as, oh, this just fell out of the sky in our lap, not that we were doing the same thing we're accusing them of being bad people to do. And I take that as a complete insult to me as the court in this case. And you were saying that he completely lied and misrepresented despite the fact he acknowledged that he had a security clearance with Global, which again is another misrepresentation of the court which supports your argument that you were being made. So right now your credibility with me, Mr. Axelrod, is about none, if you understand that.
I do. I certainly do, and I apologize when you feel that way. I apologize if you feel that I've misled you. That certainly wasn't my intention.
Yeah, well, you said, oh, I never said that. Well, no, you did. So today you said I never said that, but that's what the transcript from last week was representing. I'm reserving on any other sanctions pertaining to this matter and other matters against the lawyers and parties in this case. But at least to resolve the issue for this morning to go forward, you can get Mr. Conway here. And I'll do this too. If Mr. Conway cannot make it here, we can call him via Zoom.
That was a pretty stunning rebuke. I don't think I have seen a rebuke like that, at least not on tape, since the Rittenhouse case when the judge thoroughly reamed out Mr. Binger. It is rare for a judge to essentially embarrass a trial lawyer in this way, absent some kind of real shenanigans. And I think the judge really did believe his credibility at this point was zero. And that part about, well, I didn't attempt to mislead you, that's exactly what he attempted to do. And he said he didn't intend to do that. Well, you don't do things you don't intend to do. And it's pretty clear to me that he intended to do that. So the judge is reserving on sanctions, which means, hey, the end of this trial doesn't necessarily mean that the end of the sanctions issue is going to be the case. We are going to go look at sanctions after this. And if you've earned sanctions, genius, you're probably going to get it. So I thought this was really interesting, especially considering the fact I picked up on some of this the other day in the original part of this case. And I hope you found this interesting, useful, and helpful. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.